to Discovering the Law. My name is Lucy Rivera and I am the host of the show. This program can be watched at www.discoveringthelaw.com and your questions can be sent to us to lucinda.rivera@discoveringthelaw.com. Today we have a very special guest. We're going to be speaking about wage and hour, and we have attorney Catherine Reuben. Catherine Reuben is a founding partner at the firm of Hirsch, Roberts, and Weinstein. And she is not only a great focus and great lawyer in employment law, but she is also a very good friend of mine. Kathy, welcome to the program. Thank you for being here.
Thank you for having me. I'm very happy to be here, and kudos to you for doing this wonderful program to educate people about their rights under the law.
Well, Kathy, you're going to be part of that effort today, and along with BNN, we would like to know, tell us about wage and hour.
All right. So wage and hour laws, there are both federal laws, United States government laws, and also state laws, the Commonwealth of Massachusetts, that govern how employees are paid and what hours they can work. And this, I thought, was an important topic for us to talk about. First of all, people work for wages. It's very important to them. If they don't get paid their wages, they suffer. And it's important for employers and small businesses too, because if employers make a mistake and they violate these laws, there can be very serious penalties.
And what are those penalties?
Well, in Massachusetts, for example, employees are entitled to get overtime pay. Certain employees are entitled to get overtime pay. So say an employer owes somebody $20 in overtime and they don't pay it. Under Massachusetts law, if the employee sues, they can get triple damages. So not just the $20 that's owed, 20, 40, 60. They can also get their attorney's fees. So it's very expensive for employers if they do not abide by these laws.
Very interesting, Kathy. So employers also have to pay a minimum wage.
That is correct.
Please talk to us about minimum wage. What is it? How much is it?
The minimum wage in Massachusetts is $8 an hour, which is more than the federal minimum wage. So any business in Massachusetts has to pay their employees $8 an hour.
And who gets paid the minimum wage?
Anybody who's working as an employee is entitled to get the minimum wage. And so sometimes you get into some interesting issues where someone says, well, they're a volunteer. And both the federal and state government do not take there's a concern about possible exploitation. So for example, a business might say, well, if a person is an illegal immigrant, they're not authorized to work in the United States, well, you can volunteer for us and we'll pay you a stipend that's less than the minimum wage. That would be unlawful. If a person is working as an employee, they are entitled to that $8 an hour. And they're not truly a volunteer if they're doing regular work that a regular employee would be doing.
And speaking of that, Kathy, what would be an employee as opposed to a contractor or an independent contractor? And do they get paid the minimum wage? Are they entitled to this?
That's a fascinating question because, so who's an independent contractor? Your typical independent contractor is the plumber, okay? The plumber comes into your home, he brings his own tools, he says, step aside. You don't tell the plumber what to do, the plumber tells you what needs to be done. The plumber sets his own rates, sets his own hours, and he's got his own business, or she has her own business. I don't want to be sexist about it. So that's the typical independent contractor. And the typical employee is the person who's being told what to do. Take that pallet and move it over here. And under Massachusetts law, if somebody is an employee, they have certain rights. They have a right to workers' compensation. There's unemployment. They have the right to the minimum wage. Taxes need to be taken out. So Massachusetts has a very strict statute, a strict law regarding who is and who is not an independent contractor. So to truly be an independent contractor, well, first of all, you have to be free from direction and control. So that's like the plumber. They tell you what to do, you don't tell them what to do. The person has to have their own independently established business. If they're only working for the one company and not anybody else, that might appear that that's not an independently established business. And here's the clincher under Massachusetts law, is that independently established business must be something different than what the employer's business is. So if you've got people who are employees and then you have people working as contractors side by side your regular employees, chances are that the federal and state government are going to look at that and say that person is not truly an independent contractor and they are entitled to the minimum wage.
Okay. Now, these independent contractors are not entitled to minimum wage?
Correct. If they are truly an independent contractor, if someone's got their own business. So I'm a lawyer and my clients hire me, they don't pay me the minimum wage. I have my own business working in a law firm and I charge by the hour and I choose what that hourly rate is going to be. But the law is out to protect individuals from being exploited. And so the idea is we don't want a situation where somebody's being hired, say, to do straightforward secretarial work, and the business says, well, we're going to treat you as an independent contractor, and we're not going to pay you $8 an hour, we're going to only pay you $5 an hour. Well, that would not pass muster under the law, and the person could have a claim. And even if the boss says, well, you have to sign this agreement that says, I hereby state that I'm an independent contractor, you're not an independent contractor unless you meet those factors. You've got your own business, you're free from direction and control, and you're not doing the same stuff that other employees working for that employer are doing.
Very good, Kathy. I think that's a little clearer. So what happens then if, whether you're an employee or an independent contractor, can you work, or can they make you work more than 40 hours a week? Who gets paid overtime? And can you make someone work more than 40 hours a week? What is the issue on that?
What's the deal with overtime? Right. Okay, because some people get overtime and some people don't.
Right.
And you often hear, well, if you get paid a salary, you get paid a straight salary, and that's all hours worked. And if you work extra hours, too bad. Well, the law, both again, federal and state law, have certain rules with regard to overtime. So the general rule is, if you are non-exempt, if you are not exempted from the law, you are entitled to time and a half for all hours worked more than 40 in a week. Okay, so once again, if you are not exempt from the law, because certain people are exempt, and we'll talk in a second about who's exempt, but if you're not exempt from the law and you work more than 40 hours, those additional hours you're supposed to get time and a half. So say you're working as a waitress and you get paid $10 an hour for doing that work, and you work 42 hours. Those last 2 hours, you're going to be getting $15 an hour.
I know you said exempt and non-exempt. So who are these exempt people and these non-exempt people?
Well, the law there's a number of provisions in the law regarding who's exempt and who's non-exempt. And there's a number of things that are exempted, types of jobs. But the ones you hear about the most are what they sometimes refer to as the white-collar exemptions.
Okay.
So a general rule of thumb is the more high-level positions, it's more likely the person will be considered exempt. But the particular exemptions that you hear about, one is called the executive exemption. If you're the boss and you're supervising 2 or more full-time employees, then you're not entitled to overtime.
Okay.
You can be paid by a salary, and very often managers have to stay late and they don't get extra work before that. But to be exempt under the executive exemption, you must be supervising 2 or more full-time people. Then there's a professional exemption. All right? Those are your doctors and your lawyers and your accountants, people who have high-level experience and training. And those persons, likewise, can be paid by a salary and do not have to be paid time and a half for hours worked in excess of 40. Now, who's a professional? There's some controversy around that. So lawyers are considered professionals. Most of the cases indicate that paralegals, generally speaking, are not considered professionals. I mean, we consider them professionals in our mind, but they don't meet the standard under the law, and they generally are entitled to overtime when they work more than 40 hours. And there's a lot of other little sort of subtle distinctions. Nurses. A registered nurse, generally they're considered exempt from overtime, meaning they can be paid by a salary for unlimited number of hours. No matter how many hours they work, they get the same salary. But an LPN, a licensed practical nurse, generally speaking, they are considered non-exempt, and they are eligible for overtime. So there's always a lot of cases around who's exempt and who's non-exempt. There's also some exemptions related to high-level computer professionals. So if you're the guy operating the network, generally speaking, you're going to be considered exempt. If you're the help desk person, hi, can I answer your questions for you? Or you're just inputting data, you'll generally be considered non-exempt, and you'll be entitled to the overtime.
It's very interesting, this overtime and who gets paid and who doesn't get paid. That's seems kind of, sometimes supervisors work even longer hours, and so what do they do when they have all this overtime? They just,
again, if they are an exempt employee, the employer can choose to pay them by a salary, and that salary is for however many hours it takes to get the job done. And there are a lot of people who are working very, very hard and very long hours, and whether that's good or bad or for society is not an issue for us to discuss. The question under the law is, does the employer have the right to treat them as exempt? Another thing to remember, though, is if the employer wants to treat you as exempt, you have to get a guaranteed weekly salary. So say you leave a couple hours early, and the employer docks your pay by 2 hours. Well, that can threaten your exempt status. So
That's
employers need to keep that in mind, that if someone, just because you pay someone a salary, doesn't make them exempt. But if you want to treat them as exempt, and they are truly exempt, they're truly a professional, they're truly an executive, then they must get that guaranteed weekly salary.
And if you dock the 2 hours, do you get paid?
That can threaten the person's exempt status. And then the person might, if they might then go to the Attorney General and say, hey, I was not treated appropriately as an exempt employee, and look at all these extra hours that I worked, I'm entitled to that overtime.
Kathy, on the flip side, can an employer make their employees work late?
Okay, so the employer says, hey, we got a big job in, everybody's got to stay late tonight. But I got to get home and take care of my kid.
My kid.
Nope, you got to stay, and if you don't stay, you're going to get fired. Is that legal? Well, if the person does not have a contract, say they're a union employee and there's a collective bargaining agreement, but if there's no contract, employers do have the right to say to employees, hey, a condition of this job is if we need you to work late, you're going to have to work late. Now, being a good employer, you want there to be morale. We want morale to be high. You want to try to treat your workers fairly. You don't want to try to create hardship for families. That's good business practices. But in terms of the law, the employer does have the right, again, if there's no contract, to require employees to stay late. And you don't want discrimination either, All the men have to stay late and the women don't. That would be discriminatory, and that would violate other laws. But if the people are forced to stay late, they have to get paid for that time. And if they are non-exempt and they work more than the 40 hours, they must get that time and a half. There have been some cases involving, so sometimes you see employers, and what they do is they'll say, if you do the secretaries, well, you're not permitted to work overtime without authorization because we don't want to have to pay that. So you can't work extra hours unless you get permission. That's fine for the employer to say that, but what an employer can't do is say, listen, you got to stay and get the work done, but don't write it down. Okay, the Department of Labor doesn't like that. The Federal Department of Labor, they will come in and they will do audits and they will do inspections on employers. Sometimes it's surprise inspections. And one of the things they're very suspicious of is if day after day the timesheet says 9-5, 9-5, 9-5, and they ask the employee, well, were you really working exactly 9 to 5 every day? And the employee says, well, sometimes I stayed till 6, sometimes I stayed till 7. I had to get it done, but the boss said I couldn't write it down.
Right?
Yeah. No, employers are expected to keep accurate track of the hours worked by their non-exempt employees and make sure that they are fairly compensated for all the hours that they actually work.
Well, for all our viewers, we are talking about wage and hour today with our attorney, Catherine Reuben, who is the founding partner, one of the founding partners of the law firm of Hirsch, Roberts, and Weinstein. And that is, her focus is employment and labor law practices. Coming back to that topic, Kathy, speaking of sharing and in your profits and working late, say, for example, the people who receive tips, who are asked to work late, and they get lots of tips. What is the issue around tips?
Well, there's some laws around tips as well. So what's a tip? A tip is a gift from the customer to the employee. So you go out for dinner and your waitress treats you well and you say, the bill is what I pay to the restaurant, but the tip is what I give my waitress to say thank you for your good service. So think about it logically. If the employer comes over to the waitress and says, hey, I get half of that, that's not consistent with the customer's intent. And Massachusetts law mirrors that logical conclusion. And Massachusetts law takes the position that if a customer gives an employee a tip, even if it's collected by the employer through the credit card or what have you, that tip belongs to the employee. And where the cases get interesting is that sometimes you see what they call tip pooling, is the waitresses will share tips with the bell staff and other people. Tip pooling is okay, but managers and supervisors are not supposed to share in tips. And there's been some cases involving, well, who's really a manager? Someone who's kind of a team leader, but they're still an hourly employee. Are they a manager? There's been some controversy around that. But the general rule that employers have to remember is that if you've got a tip, and sometimes they use the word service charge, if this is something that the customer thinks is going to the service for the employee is supposed to receive all of it. If the employer's taken off some of the top, once again, the employee could bring a claim, and the employer could face, in Massachusetts, those triple damages, which is a big incentive to do the right thing.
Yes, indeed, triple damages. Now, you were talking to me earlier about internships, and you were saying that internships now are a new issue because people are working for free. What are those issues around internships?
Yeah, there have been some news stories related to interns. So think about the concept of an intern. There's a student, and they want to get experience to fill their resume, and it's tough to find a job. So they go up to a company and they say, look, take me and let me intern with you. I'll work for free, and I can put it on my resume, and you'll get good work. It's going to be great for me. It's going to be great for you. But then we've got that law that says people are supposed to be paid minimum wage. So the question becomes, when is it a true internship where it's a training opportunity to benefit the student? And when is this just an employer having someone illegally work for free, doing work that regular employees would do? And another concern is sometimes situations involving people who are undocumented aliens, and the employer says, well, you can intern with us. Or an employer who says, well, I don't have a job for you now, but if you work for me for a couple of months for free, then I'll think about giving you a job. Well, that's called exploitation. That's not legal. So how do you draw the line? Well, the Department of Labor, the Federal Department of Labor, and by the way, the Federal Department of Labor has a wonderful website, www.dol.gov. departmentoflabor.gov, and they've got information on who's exempt and who's non-exempt, and they've got a great search facility, and they have information about the minimum wage. It's a really user-friendly, wonderful website, and it's a great place for employers and employees to go. So the Department of Labor has looked at this issue of interns, and they've come up with some set standards. They say, well, we have certain rules as to who's an intern. To be an internship, it's got to be something that's truly benefiting the student. So students are not supposed to be doing work that regular employees do. If the student are sitting next to them doing the same stuff, just entering data, they can do some real work, but if they're displacing regular employees, the Department of Labor say, that's not an internship. This has got to be something that's about benefiting the student. There's got to be an understanding that this is work for the benefit of the student, that they're not going to be paid for it, that they're not necessarily being promised a job at the end of it. And once again, that they are not displacing regular employees. Just like, we talked about, with the independent contractor. If the independent contractor is sitting next to your regular employees doing the same stuff, no, they're not independent contractors, they're employees. So it's sort of if it looks like a duck and quacks like a duck,
it's a duck.
Or at least that's the approach that the Federal Department of Labor and our Massachusetts Attorney General take.
Okay, Kathy, it's very, very illustrative. We're learning a lot today about your trade, wage and hour especially. But tell us about these small businesses and what happens to them. It's hard for a small business sometimes to...
Yeah, there's so many different laws for small businesses to keep track of, and it's important that they do. And so when you think about what are some of the most common mistakes that small businesses make. So we talked about treating employees as independent contractors and not paying a minimum wage. That's a big one. We talked about calling people exempt. Sometimes small businesses, well, let's just agree, we'll make it a salary because that's more convenient for you, that's more convenient for us. But if they're not truly exempt under the law, that can get small businesses in trouble. Another thing small businesses have to remember about is that there are laws requiring the timing for the payment of wages. So Paul business says, oh, we're going through some rough times. We'll pay you next week. We'll pay you the week after. Or we'll pay you in a couple of months. And then, well, what are, they need their money. Well, Massachusetts has a statute, a law right on point that says employees need to be paid within a certain period of time. If you have a 5 or 6 day work week, within 6 days of the date those wages are earned. And once again, if the business does not pay the employee, that's the thing, before you pay anybody else, pay your employees, because if you don't, that can be a violation, and you can, again, be subject to those triple damages, which we want to help employers avoid. We want them to do the right thing.
Now, also, as another issue is, in addition to whether you're gonna get paid for something or not, is when you are sick. If employees are sick, are they entitled to pay? And what happens if the employee does not get paid when they get sick, or is that appropriate?
This is an important issue because, we don't want people coming to work when they have, swine flu and they're sneezing on people. But a lot of employers do not offer paid sick time. There are some states where employers are required to offer paid sick time, but Massachusetts is not one of them. Employers in Massachusetts, again, if there's no contract, because paid sick time is something very often a union will negotiate as part of a collective bargaining agreement, and sometimes employers will have policies where they offer paid sick time, and if you have a policy, you need to treat people consistently in following it. But if there's no policy regarding paid sick time and there's no contract, an employer can say, hey, if you can't be here, we're not going to pay you. If you want to get paid, you got to be here. And many employers choose to offer some sick time, and the reason they do is they don't want people coming in and coughing and spreading diseases, so there's good reasons for businesses to think about offering this, but some businesses can't afford it.
And can they get fired if you're sick? Can employer
Okay, so this is a different question. So this question is, can the person says, I'm sick, I can't come to work. Employer says, well, you get your butt in here now or you're going to be fired. Can an employer do that? Well, there are certain laws that protect employees who have medical issues. So one law is a federal law called the Family and Medical Leave Act. It's also known as the FMLA.
Okay.
That applies to employers who have 50 or more employees, and it applies to employees who've worked for the business for a year and worked more than 1250 hours. So if you're really very limited hours, it's not. But if you've worked for the business for a year, you've worked the 1250 hours, you are entitled to take up to 12 weeks of unpaid leave due to a serious health condition.
Oh.
So, the common cold, generally not a serious health condition.
How about pregnancy?
Pregnancy is covered by the FMLA, because the FMLA not only covers a serious health condition, it also covers birth, placement, or adoption of a child, and it also covers care for the employee's spouse, or the person's the husband or the wife or their children.
Wonderful.
So, and there's also certain military types of military FMLA. So that's the FMLA. But so what about our small businesses again?
Well, Kathy,
we're out of time.
We're running out of time. We're gonna have to invite you again because this has been very informative. We learned a lot, and we need to know about people who get sick. Can they get paid? Are they gonna get fired?
Well, thank you very much for having me.
We are gonna have to invite you back. This was very interesting, Kathy. And for all our viewers, thank you so much for your time, for your attention. You can view this very informative episode with Catherine Reuben at www.discoveringthelaw.com. Today, you'll learn about wage and hour with our attorney, future attorney of the month. My name is Lucy Rivera. I'm the host of this program, and you can please write to me at lucinda.rivera@discoveringthelaw.com. And please, this episode and many others in our website, www.discoveringthelaw.com. Thank you for watching.